We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. I am joined today by two outstanding colleagues, Justice Wolahojian and Justice Blake. We are hearing oral arguments this morning via teleconference due to the ongoing pandemic. The first case we will hear this morning is an impounded, partially impounded case, BW versus LR, number 21-570. We will hear first from, and indeed only from, Attorney Jones for the appellant. And I would remind you, Attorney Jones, it is an impounded case and you should adhere to the order of impoundment, including not using names of the parties. And you may proceed.
Members of the panel, may it please the court. My name is Caroline Jones and I represent the appellant, LR. This is a case where the script has been flipped and where an abuser is being protected by the law intended to do the opposite. First, looking at the record as a whole, including all of the documentary evidence, it's impossible to see how a reasonable fact finder could have found that the appellee, BW, was in fear of imminent serious physical harm under Chapter 209A. Second, LR was not able to develop the record and meaningfully present her case at the extension hearing. Importantly, she was not permitted to cross-examine BW with the communications in the record that directly conflict with his allegations.
May I stop you at that point, please? Was there an objection made below to that procedure?
At the trial court proceeding, LR's attorney did attempt to cross-examine BW. The court cut short the cross-examination and directed the parties to move to closing arguments. At that point, there was no opportunity for objection. The court had
the counsel could have lodged an objection. Could have said, I object to that, Your Honor. I have some additional questions to ask.
At the trial court level, the attorney certainly tried to continue. Even despite that, LR still has a right to present her case in a meaningful way. And without a full cross-examination, she was not allowed to fully present her case. And that
I know, except that in a civil context. So in the criminal context, we would say that, and if it weren't preserved, we could still review it under a substantial risk of miscarriage of justice standard of review. But in a civil case, we actually still have the doctrine of waiver. So do you have a case that says in a civil context that despite a lack of objection, we reached the question of whether cross-examination had been impermissibly curtailed?
There's plenty of case law that says while 209 orders are informal, they still have to be fair. And I could point, Your Honor, to ST versus EM. That's at 80 Mass Appellate 423.
I think just Wolahojian's question is whether you have any case law showing that 209A cases. So there is a class of civil case in which an unpreserved objection can be reviewed under a heightened standard of review, that is to say termination of parental rights, right? That's a civil case. And criminal cases, it's our ordinary rule in Massachusetts, although it is not in all jurisdictions. Her question, I take it, is, do we have any case law that says an unpreserved claim of error in a 209A case may be reviewed at all?
Your Honor, I would say that reviewing the record as a whole, it's clear that BW did not meet the standard even if the court finds that.
Okay, so you're
there
not
was
answering
waiver.
my question. You're just switching to, I don't understand. You're telling me that there's insufficient evidence. And that, if there's insufficient evidence, I guess that's one thing. But I'm asking whether your claims about the procedural unfairness are claims we can reach, even if we conclude that they were not properly raised below by an objection.
Your Honor, I think that it's clear in the record at page 124 that the attorney did want to continue cross-examination. And a defendant's right to meaningfully present their case cannot be waived. That's clear in the case law and in the judicial guidelines.
I'm sorry, a defendant's right to present their case can't be waived?
To meaningfully present their case cannot
Can't be waived. I'd like a citation for that in a civil context, please.
I would point the court towards the judicial guidelines, which say that every defendant is entitled to meaningfully present their case. There are instances when a court can properly
cut. 209A guidelines in Massachusetts.
I'm sorry. Yes.
Okay. What section are you specifically pointing to?
That I believe is. Give me one moment.
I'll look for them, but to follow up, if I could, on Justice Wolhoge and Justice Rubin's questions, because I don't think you've answered them. I see what you're pointing to on 124. Let me ask you this. On 126, counsel tries to make an offer of proof, at least as it relates to the emails. Are you aware of any cases in the civil context that suggest that a further objection is not necessary because it would be futile if you look at the record as a whole? Do we have any civil cases that say that? Because it isn't an objection.
I don't have a case, Your Honor, at my fingertips. We can certainly get that information for the court. Well,
it was certainly raised in the letter in lieu of a brief, that waiver, and you do very briefly breeze through that in your reply brief, and you suggest, it looks like at page 12, that there was no waiver, but I don't see any cases in support of that. You talk about issues before a board of appeals. You talk about some housing court issues, and one in particular that deals with sufficient public policy concerns. Are you asking us to do something that we've not done yet before, which is to review an unpreserved claim under some other equitable theory?
Your Honor, if there was ever a case to do that, I think this would be the one, given that the record that the trial court was not able to hear on cross-examination for cross-examination purposes so clearly contradicts the findings.
Can I ask you a question about that? And I'm sorry, I don't mean to interrupt if that hasn't answered has that answered your question, Justice Blake, or not?
As best as I think I'm going to get, Justice Rubin. Thank you.
Okay, so my question is this. You say the evidence is insufficient. The plaintiff testified that your client threatened to stab him to death repeatedly, including utilizing family members who she said were involved in human trafficking of some kind. And he says that if we look, now we don't have color copies, I don't know why. If we looked at her email, we would see that the italicized portions of part of it were in red, and that this was a coded message that she was going to stab him between two of his ribs, and that this was a code that she had developed over time. If the judge found that credible, why isn't that sufficient evidence to support his fear of imminent harm?
Your Honor, this court can inspect the evidence itself, in addition to.
Well, you haven't given us a color copy. I gather that text that's in italics was also in red. Is that correct?
This is the copy that was available to us. The text itself is available for you to read. There's nothing in it on its face that
Can
could.
you answer my question about whether some of the text was in red?
I believe some of the text was in red, yes.
Okay, so he says, this is a coded message that she's going to stab me. I don't know anything about that. I've read all of the records that you've put before me. I think anything could be possible in this relationship. I have no idea. So if the judge believed that, why wouldn't the judge have had sufficient evidence, not that we make a finding, but why wouldn't that be sufficient to support a finding of an imminent threat of serious physical harm?
It's insufficient evidence because considering the record as a whole, which directly contradicts all of his allegations, and considering
what in
the
the record contradicts his allegation that she threatened to stab him?
There's no evidence in the record that she.
His testimony is evidence in the record, isn't it? You've read the Santos decision.
Yes, but when there is documentary evidence that undermines the allegations, the court should take a close look at those. This is not a case where there's.
I don't know if the court took a close look or not, but I do know that victims of sexual violence and other violence, domestic violence, come into court all the time and tell stories that may seem implausible to someone, but they're true. And I wouldn't want a victim of sexual violence to be treated as though he were not. And I understand it may be that your client could have gotten a restraining order against him. I don't think she sought one.
That is true, Your Honor. But we have text messages in the record that clearly show he was not in fear of imminent
show
serious
that she
harm.
never threatened him with stabbing.
I think looking at the totality of the evidence, it's clear that he was pursuing a relationship with her.
Are you
actively during this
unfamiliar
period.
with victims of sexual violence who nonetheless sometimes pursue their victimizer? Have you never heard of that?
I have heard of that, Your Honor. I don't think that there is evidence that that is what is happening in this case.
May I jump in for a second? It seems to me that what you are asking us to do is to reweigh the evidence. Because when you ask us to look at the totality of the evidence and to come to some conclusion other than what the trial judge did or the judge below did, that's what it sounds like to me, that you're asking us to essentially review the transcript, look at the exhibits, make a factual determination de novo, without having the benefit of, and I realize it was only a Zoom proceeding down below, but the judge was able to see the parties on the Zoom, correct?
Yes.
Okay, so we are in actually not as good a position as the judge down below. Can you tell me why it is or how it is that we get to assess the factual record de novo?
This court can assess how the law was applied to the facts, and in doing that can inspect the record itself.
Right, so but we need to, right, what is the standard of review on appeal for the judge's factual determinations? Because the judge found that the plaintiff was in fear of imminent serious physical harm. So,
yes.
So what is the standard of review of the judge's factual determinations?
So this court can review the issuance of a 2098 order for abuse of discretion or other error of law, but can also supplement the trial court's findings with inspection of the evidence. And that's at Shimkowski versus Shimkowski, Your Honor.
Can I ask you about the documentary evidence that you put before the judge?
Yes.
When did she get it? How long did she have to review it before the hearing began?
The LR was not provided with BW's evidence before the hearing.
I asked when she got your evidence. Your evidence suggests that he's lying.
When the judge got your evidence.
Yeah, when did the judge
Yes.
receive your evidence? How much time did she have to review it? I ask because she ruled immediately after the hearing. And if she hadn't gone through the documents or couldn't have because there was inadequate time, that might be a different story. I gather, go ahead.
Your Honor, our position is not that the judge didn't have the evidence before her. She did. However, and this is where the procedural issue comes into play, particularly because cross-examination was not allowed here. LR was not able to confront BW with those text messages.
Well, she confronted him with some of them, and he said, "I don't know," in response to whether he had written them, which might call his credibility into question. And I'm trying to figure out if the judge had sufficient understanding of that circumstance, which is why I've asked you twice when the judge received the evidence from you. Was it immediately before the hearing? Was it submitted in advance?
My understanding is that it was submitted in advance. Your Honor, I think the issue here is that the judge did not have the benefit of, and with leave from the court, I will answer.
Yeah, you can finish.
Thank you. The court did not have the benefit of the cross-examination on all of these text messages, which are very clearly undermine both BW's credibility and his allegations. We asked, in closing, that courts, have clearly recognized that the issuance of these orders have long-term collateral consequences for defendants like LR. This was an unjust order, and we ask that it be vacated for all the reasons in our brief.
Okay, thank you very much. Of course, we also have your submission. It's an excellent argument, and it's very helpful to us. So thank you very much. We appreciate it, and the case is submitted.
We are live and on the record.
Good morning. Our session here at the Appeals Court continues with number 20-1409, Bonafini versus Denise and another. I note that we are hearing argument by teleconference due to the ongoing pandemic. The rules for argument are the same as in our courtroom, 15 minutes per side and no rebuttal. And I should have said, I'm Justice Rubin, and I'm joined on today's panel by Justices Wolohojian and Blake. We will hear first from Attorney Beeler.
Thank you, Your Honor. Good morning, Jeffrey Beeler for the plaintiffs. With the court's permission, I'm going to dispense with the recitation of the facts and hopefully dive right into the duty of care issue, which is at the heart of this appeal. This case was dismissed on a motion to dismiss, which was the second motion to dismiss that was filed. I know the court is well aware of the applicable standard of review.
I thought it was a motion for judgment on the pleadings.
It was, Your Honor, which of course is treated exactly the same as a motion to dismiss for purposes of the appellate standard of review. And essentially it was the same type of argument made in front of a second judge. The Superior Court judge, in his written opinion, invited this appeal by saying that he was not going to wrestle with public policy issues related to whether a duty of care should be recognized in this type of suicide case, and that it was best reserved for the appellate courts, and that is why we are here. I would suggest that this court's recent case of Navarro versus Burgess for less than a year ago, sets forth a very concise a recitation of what the courts consider when determining whether or not there's going to be a duty of care. Specifically, courts will find a duty of care where in general reasonable persons would recognize it and agree it exists. And a duty finds its source in existing social values and customs, and thus imposition of a duty generally responds to changed social conditions. Of
Can I
course,
ask you a question specific to the record here?
Of course.
So let's say I were to agree with you. I wouldn't call it a duty to prevent suicide, but let's say I were to agree with you that if an innkeeper receives credible information that someone is in a room in their in, planning imminently to commit suicide, that they have a duty to take some reasonable step. In this case, twice the front desk clerk called the room. I don't know, and this may be a question of fact for a fact finder, but the first time, I don't know what the front desk person said, but the person in the room responded that he didn't wish to be disturbed. And the second time he hung up. And these are on 2 consecutive days. Are you asking us to find that as a matter of law, that is not sufficient to discharge the duty? And when might it be and when might it not be? For example, I go to my hotel room and I'm sitting there. Someone who is whatever wishes to disturb me or get me to do something or something comes to the hotel, can't figure out how to cause consternation to me or rouse me from the room or something, and says he's in the room, he intends to kill himself. So the clerk calls and says, Judge Rubin, I understand you're in the room, you intend to kill yourself. And I say, could we put a do not disturb, please, on this line? Thanks very much. You see my point? I'm just trying to figure out if I find a duty, how we know what's adequate to discharge it.
I do see what your point is, Your Honor. And what I would suggest is the facts of this case are a little bit different than your hypothetical, as I'm sure you can appreciate. Day one, the message from the decedent was he did not want to be disturbed and the hotel provided no information. Day two was he picked up the phone and hung up the phone. At best, on this record, what that tells us is he was alive. On day three, when the mother went back, or when the wife went to do the same thing, try to get assistance, they did nothing. All they did was wait until noon when 3 of them went into the room. And I would suggest if they didn't anticipate bad things at checkout time, it wouldn't have been 3 people going into the room.
May I ask you a different question? To whom, in your view, were we to find a duty? Would the duty run?
Your Honor, I would suggest that the duty—
To the hotel guest?
Certainly to the hotel guest. That's the person whose life is at stake, and this is a wrongful death claim with essentially the estate stepping into his shoes.
Okay, so then it seems to me that anything the mother or the wife did is quasi-irrelevant. If the duty runs to the guest and the guest has asked nothing more of the innkeeper than what the innkeeper did here, what's the problem?
The problem is public policy in Massachusetts says we should do what we can to assist people in avoiding committing suicide, Your Honor. And I would suggest that the mother and the wife's comments to the hotel are critical, because information about somebody being at risk of suicide very frequently comes
But
from—
I understand all the policies, and I'm even willing to accept they're incredibly laudable, and we should all be trying to prevent harm. But if the duty runs to the guest, and the guest, what this guest has asked for, I guess, is to rent a room. That's what he's asked for. The duty doesn't arise from the contractual relationship between the innkeeper and the guest, I take it. Right?
Well, it can certainly duties of care can arise from contracts and arguably—
Right, but that's not what you're alleging here. Maybe I should be clear, right? You're not saying there was some duty that was created by virtue of the rental of the room contract.
That's correct.
Okay, so we're looking at some kind of common law duty, which I did a little research before this argument, not exhaustive, but I couldn't find anywhere in the country a state that created a common law duty on an innkeeper simply by virtue of renting the room to someone, that the innkeeper then had a duty to prevent that person's suicide.
Your Honor, I think I cited at least 2 cases that were pretty close to
Simply by renting the room.
It is a duty of care that arises out of the special relationship between an innkeeper and its guest, however you want to define that relationship as arising. And under the restatement 3rd of tort section 40 and the restatement section 2nd section 314A, that duty of care arises simply because of the special relationship. And the default standard and duty of care in that situation is reasonable care under the circumstances. One of the problems with focusing solely on the person at risk of suicide is that you're almost by definition dealing with somebody who is not in a position to think rationally often about their own safety. They're laboring under the mental distress. I got into this with the Wen court at the SJC, and they made a lot of, I would suggest, mistakes in connection with this particular issue, because putting this all back on the person laboring under the mental illness who is known to be at risk of suicide, where there are systems set up to help these people when police and medical professionals are trained to deal with this, I would suggest turns the current prevailing public policy in connection with this issue on its head. I
take it that that none of the family members called 911.
That's correct. That's correct.
Can I ask you, Attorney Beeler, I just feel like you're making it harder for yourself than you have to by calling it a duty to prevent suicide. And I'll ask your brother about this. I assume that if a person ran into a hotel and said to the front desk clerk, I was FaceTiming with Bill Smith, who's staying here at your hotel. I don't know what room he's in. I just know he's at your hotel. And during the FaceTime, he injected himself with heroin, too much heroin. And then he flomped over. I believe he's overdosed and he's lying unconscious in your hotel room. I think we would say that if the desk clerk said, I'm sorry, can I help you with anything that I would like to rent a room? I'm not going to act on this. We'd say that they had breached the duty of care that arose from the special relationship. It seems to me, maybe I'm wrong about that. I'll ask your brother, but I would think that when credible information of a risk of serious harm to a guest comes to the attention of an innkeeper, under the, my guess is this goes back hundreds of years, but I don't know. My guess is they have some kind of relationship. Among other things, they're the only one who knows what room the guy's in, among other things. So, but even beyond that, it just seems to me that makes perfect sense. Well, let me call the police then. There might be a dead person dying in one of the rooms. Okay, this is a little different, in my view, only because the person can respond. If they came in and said, he has, in order to kill himself, swallowed a bottle of pills and is now unconscious in the room, I don't think anyone would doubt that they're supposed to call 911. That's why I asked you about this question about what you have to do to discharge the duty. It seems like there is a duty, but when you have a conscious person who someone says is in distress, the question of what you have to do exactly. And let me also say, I don't want to suggest that I necessarily agree with you that the inference from what's written in the complaint, and I'm guessing you didn't draft the complaint, but I don't know. The complaint says he was at risk of suicide. Maybe the reasonable inference is he had gone to the hotel to commit suicide, which seems like the stronger case to me. I'm not sure about that either. But just in terms of what the framework is, I don't know why it has to be couched as a duty to prevent suicide, rather than just an ordinary duty of care that comes with this. And that happens to be the facts here.
And Your Honor, first of all, I'm not the one who's been, well, I have, because I've adopted what the courts have been doing this and calling it a duty to prevent suicide, but I think that's overstating what we're talking about for the very same reasons you just described. What we're talking about here is nothing more than fundamental negligence law, reasonable care under the circumstances presented. And your question about where to draw the line on the duty of care in this situation, that would lead us headlong into another dispute I have with what the Wen court did. We're here on a sole question of law about whether a duty of reasonable care under the circumstances exists, period. If it does, the proper way to address your question is to allow discovery to occur and then to put all of that into the mill, both at summary judgment and for the jury to decide whether that initial phone call you mentioned was reasonable care under the circumstances, whether the second phone call when they got no response whatsoever.
Well, we have to set a legal, I mean, it's a mixed question, right? I mean, something will be so obviously adequate that we would say nothing more is required as a matter of law. You know, I mean, I get, but I take your point. I take your point, you know, that sooner or later the facts have to be, maybe not in this case, I don't know, have to be developed. You're fighting the Wen case. That seems like a much harder case than this to begin with. I mean, both because I don't think we'd say, if I rented a house and that's just where I lived and I pay the rent every month, I don't think that the landlord of my house would exactly have the same duty to me that an innkeeper does. And I also think that in the university case, in the Wen case, that was a long and complex story of complicated relationships with faculty advisors, and they're saying words that are triggering actions, and it's a morass in a way to begin. And it seems it's not even clear, although I know that what they said the duty was limited. You can imagine you're talking about questions about what is suicidal ideation versus just, someone. This is just nothing like that to me. This is someone, if we read the record the way you say, someone comes in and says, there's someone who has come to your hotel, as happens, in order to commit suicide. So,
and just
can I ask you though, Attorney Beeler, what do you say the hotel should have done?
At bottom, they should have picked up the phone and called for a wellness check. That would be in accord
To
with
the police.
To the police. That is who you dial 911. You explain the situation. They come in. Not only is that common sense, not only did the Wen court say, if you're confronted with the situation, that response would be obvious, but as mentioned in both the papers below and in the papers in front of you, ultimately this entity produced its own internal policies, which suggest that that's what they're supposed to do anyway, which would be evidence of their own negligence based on those.
We don't have that before us, right? Or do we?
Well, it was a motion to dismiss, Your Honor. I wasn't in a position to present any factual information. I offered it both to the court below, and I've offered it to you in the filings. We have it, and that
was it. I'm sorry. Did the court refer to it or accept it or do anything like that?
No, the court did nothing. The court received a status inquiry and shortly thereafter issued its decision saying that.
And so when you say you put it before the court, you offered it to the court, what does that mean?
What I mean is I'm pretty sure in the brief below I mentioned we had it and said it's available to the court if the court wanted it. I certainly referenced it in the oral argument, the transcript of which is in front of you in this case, and mentioned that it was available and also indicated exactly what I just mentioned to you to the Superior Court judge. Nobody asked for it, therefore we didn't submit it because of the procedural posture of the case.
Okay. If there are no other questions from the panel, okay. Your time's expired. Thank you for an excellent argument. We'll hear next from you, Attorney Lewis. You're muted though, so.
Thank you, Your Honors. May it please the court, my name is Paul Lewis on behalf of the defendants' appellees. Here, while the defendants certainly appreciate how horrific of a situation this would have been for the decedent and the decedent's family, it is nevertheless the defendant's position that the Superior Court's grant of the defendant's motion for judgment on the pleadings should be affirmed in its entirety. Before this court are two different grounds to affirm that grant of motion for judgment for the pleadings. First, the defendants argue, and this is what the Superior Court found, the only issue that it reached, that under the circumstances alleged, under the appropriate standards at a 12B6, or in this case, a 12C. Both standards are the same, as my brother counsel pointed out in his brief. There was no duty here that could have possibly been imposed upon any of the defendants to take any action in furtherance of preventing their guests, the decedent's, suicide. The second issue before this court right now is that even if some duty to some degree could hypothetically have been imposed here, such duty was not breached because there were no other steps that could have been required of the defendants under the circumstances in this hypothetical as a matter of law.
Can I ask you this? Can you answer my hypothetical question? A person runs into your hotel, motel, whatever it is, and says to someone at the front desk, I was FaceTiming with someone staying at the hotel. He said he's going to kill himself. I saw him take a bottle of pills, swallow them all. I believe he is now unconscious in his room. Duty, no duty?
Your Honor, I think that it's conceivable that there would be a duty there, but such a duty has not ever been recognized in Massachusetts. Indeed,
okay, but you think there would be a duty?
I think that if there's credible evidence of someone who has already undergone some sort of emergency situation, call it a heart attack, maybe. So now they're lying on the floor and they need medical attention. And for some reason, the only mechanism of getting to emergency responders is to call 911, then I think
Well, I don't know what you mean for some reason. The reason is they're in a hotel. No one knows what room they're in except you. And they're lying unconscious. I mean, that's the reason, right?
Yes, Your Honor. And here the Superior Court actually pointed out that the fact that the risk of harm was prospective, that the harm itself hadn't happened yet, but that the risk of harm was in the future, and that's the way that it was articulated, is an important point here. But perhaps more significant is the fact that this is self-harm. This is self-harm, as arguably in the hypothetical that you posed. And the SJC in the Wynn case has demonstrated that in the context of self-harm, to the extent that a duty to prevent it is ever going to be imposed upon a non-clinician, the standard is high. There's something inherently unique. All of the cases in Massachusetts.
But you're saying non-clinician. This just doesn't seem clinical to me exactly. No one's asking you to make a determination. Oh, are they a harm to themselves or others? I am not a clinician. I don't know how to make that determination. Obviously, you don't know how to make. I don't know how to make that. I mean, I read things that say, do they have a plan? But I don't know what that means, right? So I'm not a clinician. You're not a clinician, and the front desk clerk isn't a clinician. But no one's saying make a clinical judgment. Is there an emergency that requires calling the police or fire, EMT, whatever, the police, let's say 911 anyway. And I'm trying to figure out where that line is. Now, the person in your hotel room who they were FaceTiming with takes some LSD. And they're talking to their friend, and it's a high rise. And eventually they say, I think I can fly. I really do. The friend is terrified by this, races over and says to the clerk, there's someone not unconscious, conscious in your room on the 27th floor who has taken LSD and believes they can fly. And I think they're going to try to jump out the window. And you call the number, you call the room and say, Mr. Jones? And Mr. Jones says, yes. And you say, what's going on, Mr. Jones? You find I'm not only fine, I can fly. Goodbye, click. You have to call 911?
Your Honor, in that scenario, I think that perhaps a hotel would call 911, and I think there might be moral arguments that they should. However, it would be the defendant's position there that if they do not call 911, in that scenario, they cannot be held liable. And that's consistent with
Guy jumps out the window. He just told the clerk. The clerk has been credibly informed he's taken a psychedelic drug that alters perception, and they've confirmed that through the phone call that the guy says he thinks he can fly, and he jumps out the window. I think that sounds like a situation where maybe there's a duty before he jumps out the window. I'm just trying to get at the perspective, where the prospective versus retrospective harm comes from.
What you're describing, Your Honor, in the scenario that you're describing, the harm has not occurred. And once again, I certainly feel I certainly feel the sentiment that you're describing. They probably should, and they probably would, but there is no.
But duty is about should. We find duty where someone should act, where moral and reasonable people would agree someone should act. Now,
I take it.
I'm sorry.
I take it that that the question in this case and is maybe twofold. The first being whether on the facts alleged, which taken in the light most favorable to the plaintiff because it's a motion to dismiss standard, which is a guest checks into a hotel room for 3 days. On the first day he's there, a family member comes and says, "Would you please tell me the person's room? The person is at risk of suicide." And the clerk says, "No, I can't tell you his room." Calls though, gets a response from the guest who says, "Please don't disturb me." And the first question is, at that moment, was there a duty to do something more than that? And if so, was it breached? The next day, something similar happens. And so the question is the same for the second day. On the third day, the wife comes, second family member comes, I guess repeats the same thing, but by then when they go to the room, he is dead. So the first question, I guess, is if a family member comes in those circumstances and says the person is at risk of suicide, which doesn't sound to me exactly like the kind of circumstance Justice Rubin is describing. There's perhaps immediacy, perhaps not, I'm not sure. Is there a duty to, as the plaintiffs are arguing, call 911?
No, Your Honor.
That seems to me the simple first question, because clearly the clerks did something. So, but what they're saying is that wasn't enough. They needed to call 911. You say no. And what is your best case to support that answer? If we were to accept that the relationship between an innkeeper and a guest is a, quote, special relationship giving rise to affirmative duties.
So, Your Honor, I think as you pointed out, the question is twofold. The first is there a duty to do anything in any scenario involving potential suicide that could plausibly be imposed upon a hotel? To that, the defendants would answer no. As Your Honor pointed out during my brother counsel's argument, there is no good case law in 2021. There is no state decision that has held up to its highest appellate court that has ever imposed such a duty upon a hotel to take any steps to prevent the suicide of its guest. Even if there was such a duty, we have guidance from the SJC about, in a university non-clinician context, the circumstances, the prerequisites to which the triggering of the duty must be limited. As the Superior Court found, this is how the Superior Court's decision proceeded. Neither one of the two prerequisites, either that there was a recent suicide attempt or that there was specific.
But can I just try to, sorry, because my question was both long and no doubt unclear. Let's try to not call it a duty to prevent suicide. Let's call it a duty to have called 911 in these circumstances to ask for a wellness check, because that's what I understand the plaintiffs are now arguing is the duty. That in this information, the clerk should have, because preventing suicide to my mind means the clerk has to go to the room, grab the guy, whatever, none of that. We're talking here about something else, which is when someone comes in and says a guest here is at risk of suicide, Does the clerk need to do something beyond what the clerks did here? And what the plaintiff is arguing is call 911 and ask for a wellness check. And what is your best case? Because this would take it more into a general negligence theory that says no, rather than the specific Nguyen case.
So assuming for the sake of argument that there would have been a duty to do something that could have possibly been imposed on a hotel in this context, of course, the defendant's second argument that there was no breach. As my brother counsel already pointed out, he's suggesting—
I asked for a case.
Yes.
Usually
Yes, Your
people tell me something like Jones versus Smith.
Yes, Your
something
Honor.
Like that.
The city of Los Angeles versus Patel from the US Supreme Court states that a hotel owner cannot be punished, be penalized for refusing to divulge constitutionally protected information and that hotel registry information containing
No,
guest—
that's, again, my question must not have been clear. I'm looking for a case that would say you don't have a duty to pick up the phone and call 911.
Your Honor, the Shine versus Vega case by the SJC states that even in an emergency situation with life-threatening issues, if somebody expressly declines consent for any treatment, any life-saving emergency treatment whatsoever, there is no obligation beyond that by the individuals, by the other relevant actors, and further that they could be held liable if they do administer additional treatment. So even if they could have been compelled to divulge this constitutionally protected information.
Well, look, this is a red herring. Hotels all day long call the police and tell them what room someone's in. I think he's bringing prostitutes in there, officer. I'm sure your front desk clerks do that, don't you think? So to say it's a top secret in some way that you can't share with the police, I understand, don't share it with private people. But all day long, something's happening and you guys are calling the police and telling them what room someone's in. So it's not sacrosanct, like, you know what I mean? I don't get that.
Your Honor, there's an important difference there. In the Patel case actually brought this out. If the hotel can certainly consent, the hotel can certainly make the decision to divulge that information because that's their constitutionally protected right. But
I'm sorry. Okay. And sometimes I'm guessing you have to. Now, I don't know if there's a case about a guy lying unconscious in a room and the clerk knows and doesn't do anything. But I think we'd say that they had breached a duty by not doing something to help the unconscious person. I think you'd probably agree with that. If the crime had already occurred and they found out about it, there's a man lying unconscious in your hotel. You don't let them die in there, right?
Your Honor, I think that there's a good argument that they probably would. There's no case law stating that they would be held liable if they didn't, especially not for Massachusetts. But I do see Your Honor's point. But importantly, that's very, very, very different.
It may be different, but it demonstrates that the sacrosanctness of this information isn't the critical.
Your Honor, that would be an emergency situation that would obviate the need for a warrant through Fourth Amendment analysis.
We can talk to the police when they come, but I'm asking about the hotel clerk calling them.
Yes, Your Honor. So that's once again divulging registry information that's constitutionally protected to the government against the hotel owner's will. The hotel owner has the right to assert the Fourth Amendment rights within that constitutionally protected registry. If there's a warrant or a subpoena or an emergency, it's different. And this is classic Fourth Amendment analysis. But the hotel owner cannot be penalized absent those scenarios for refusing to divulge that information. What you described, Your Honor, is an emergency. So of course, those protections would be obviated. There would be no need for a warrant. But here, we do not have an emergency situation under the circumstances.
Your time is expired, but I want to make sure Judge Wolhogen and Blake's questions have actually been answered, and I'm not sure they have. So do you have more?
No.
No, you're good. All right. Thank you. Very interesting and
We are live and on the record.
Good morning and welcome back to the appeals court. Our morning session continues. I am Justice Rubin, joined today by Justices Wolahojan and Blake. The next case we will hear is number 21-629, Lambert versus Denaro and another. And we will hear first from Attorney Brustowicz.
Thank you. May it please the court and good morning, Your Honors. My name is Catherine Brustowicz and I represent the appellant, Officer Craig Lambert, in this appeal. I'm here today to ask this honorable court to find that Police Chief Denaro acted in an arbitrary and capricious manner amounting to an abuse of his discretion when he denied Officer Lambert his lawful request for a LEOSA card. Here's why.
Can I actually just jump right in, counsel? There's something in your reply brief that just befuddles me. On page 8, you say that the 5-day suspension was served. How, when, where? Show me something in the record that says that Lambert served the 5-day suspension.
Certainly, Your Honor. So the chief wrote his reasons for denying Lambert his card was that there was an open investigation, which he admits in the record was closed, and that Lambert was facing discipline up to and including termination, which he was not, as outlined in the chief's August 22nd, 2012 disciplinary.
I'm sorry, can you answer Justice Blake's question?
Yes, so Your Honor, on page 38 of the record, which is the August 22nd, 2012 disciplinary letter, the 5-day suspension was delineated and served on August 22nd, 23rd, 26th, 27th, and 28th. And Lambert served those days. His pay was docked for those days. He did not come into work. He was not serving as a police officer.
No. Hold on. This is when the chief said he would be serving the suspension. And I have to assume that those dates were consistent with his schedule. And we know police don't work, the 9 to 5 Monday through Friday schedule. This is his notification that this is when the chief was imposing it. I want to see something in the record that says Lambert actually served it. I think we have the question about one day, that being August 21st, 2012, whether it was sick, line of duty. We know that there was a different civil service process and he was made whole financially. But let's assume for the sake of argument that I would agree with you that August 21st, 2012, he served one day of his suspension. I'm not suggesting that I am, just for the sake of this question. Where in the record do we have that he served the additional 4 days?
Well, Your Honor, restoration of his pay doesn't somehow, excuse me, alter the nature of the discipline that had already been imposed upon Officer Lambert.
Right. I'm giving you, for the sake of my question, he served that one day, August 21st. Show me something where we have August 22nd, 23rd, 26th, 27th, and 28th in the record that shows he served that suspension.
Your
Right,
Honor,
that's in his personnel file. I don't see that in the record.
Your Honor, within the record, there is nothing that shows that he either did or did not serve that 5-day suspension. It does come down to the fact that his pay had been docked. I understand that later in 2013.
By one day, right?
No, it was for those 5 days, Your Honor. That was within the 2013 separate proceeding. But I would pose that restoration of his pay doesn't somehow reopen an investigation or alter the nature of that discipline, which really is the two reasons that the police chief gave.
May I stop you for a minute? Justice Blake's point is that in your reply brief, you state that he served the 5 days of suspension. In fact, 4 of those days occurred during the period when he was on, whether it was medical or injury leave, correct?
Not quite, Your Honor. He was actually
He went on leave. He went on leave on, according to my notes, but August 21st.
That was sick leave, Your Honor, and that didn't get categorized as 111F leave or injury leave, if you will.
So he was on sick leave, and the dates of his suspension fell after that, correct? While he was out of work. He was not on duty.
He was not on duty, that's correct.
He was not on duty. Okay, so now I take it his pay was docked for the 5 days,
Yes, Your Honor.
but he was off duty for reasons other than the suspension.
He went out on sick leave as of the.
Okay, so that's, she's just trying to clarify that, which I think we now have, that the statement in your reply brief is not altogether accurate.
That's not my understanding. My understanding is that he did serve those 5 days worth of this.
I'm sorry, can you be suspended from work while you're not at work? What the heck is that?
I understand.
If I'm out sick and I'm supposed to be suspended from work, is that a suspension, or we have to wait till I'm back and would be at work and then I'm suspended?
Your Honor, I believe that this case doesn't hinge on whether or not.
Well, it sounds like it might. So maybe, right? Because if he still faced 4 days of suspension, that might well be facing discipline. Now, I understand your statement that it's not the exact reason stated by the police chief, although in this case, in some cases, obviously, for example, a PROC review or whatever, we might say the reason given has to be the reason. And if that's not the reason, then you can't take the action. But in this case, if he faced, this is a legal question, if he faced discipline, even if it's not for the reason that the chief said, he's not entitled to this card. And so that's, I think, why Justice Blake began with asking you about whether he still faced 4 days of suspension. I have questions about 55 days of suspension, but I'm happy to start with the 4. So if someone were to think that it turned on it, you can't tell us that he didn't still face 4 days of suspension, right? Because unless you know something about being suspended when you're sick, when you're out sick anyway, counts as suspension. I don't know about that. I just don't know about that.
So the 5 days were suspension without pay, is that correct?
The 5 days were without pay, that's correct. He was docked his pay. He wasn't paid through sick leave. He wasn't paid at all for that.
And then there was a subsequent proceeding which restored that income.
That proceeding was on his 111F status. Yes.
And he was restored his pay.
For those 5 days, yes.
Okay, so.
Because in part they said you can't be suspended while you're out on sick leave.
But Your Honors, suspensions can be paid or unpaid. That's not dispositive.
So he hasn't been, so he has neither, if I'm not mistaken here, I take it what Justices Wolohojian and Blake are saying, and I didn't focus on this. He has neither served 4 days of that suspension in the sense of not being able to come in when otherwise on active duty, nor has he been docked any pay for those 4 days as of now, and yet he retired. Is that correct?
Well, he was docked those 5 days worth of pay.
It was given back to him because it was improperly done, not because the suspension was wrongful, but because you can't do it during that kind of leave. So when he came back on active duty, he would have faced four days of either docked pay or not coming in, one or the other or both, right?
He had already been docked the pay, Your Honor. So I don't believe that
I'm sorry, the pay was restored to him because it was improperly docked. Do you agree with that?
It was decided that it was.
That's a lot like not being punished at all. Don't you agree?
I don't agree with you, Your Honor.
You think having your pay docked and getting it back counts as punishment?
I agree that the fact that he has this disciplinary letter in his personnel file and that this is now being held over his head is a reason for not being granted his Leosa card certainly is punishment, Your Honor. Again,
no, I'm asking, boy.
So if we were to conclude that he has neither been docked the 5 days of pay that the chief ordered as discipline, nor has he been suspended from active duty for the full 5 days that the chief ordered as discipline, then why don't you proceed with your argument, assuming that that's the case? In other words, that he still hadn't served the discipline that the chief had ordered for the violation.
All right, thank you, Your Honor. Chief Denara's basis for denying Officer Lambert's Leosa card is not supported by the record, and no reasonable person could find that the reasons offered by the chief were true. There are no multiple interpretations. The chief's reasons are false. The chief decided that Officer Lambert did not retire in good standing and set forth his reasons for coming to that decision in writing. That's on page 31 of the record. Contrary to Chief Denara's written assertions in that October 2nd, 2017 denial letter, Officer Lambert did retire in good standing, as defined by the Haverhill Police Department's rules. And he has the right to that Leosa card, and the reasons are fourfold. First, the chief gave 2 reasons that Lambert was not qualified for his Leosa card. And it reads, quote, Mr. Lambert does not qualify as he left employment under a disability prior to the completion of an internal affairs investigation, which could have potentially resulted in discipline up to and including termination. But as the record reflects, there was no open investigation of misconduct by Lambert at the time that he retired in 2014.
Can I ask you about the May 2013 hearing?
Yes, Your Honor.
Why wasn't it held?
That is an excellent question, and the record doesn't indicate why it wasn't held, but that hearing was on the question of whether the 5-day suspension was for just cause.
Okay, so let me ask you about the 55-day recommendation.
Yes, Your Honor.
How is it that you say that was supposed to be determined? That is, at what point and how procedurally does a recommendation like that get determined? I guess it's the appointing authority that ultimately decides?
Yes,
How?
Your Honor. So that appointing authority was the mayor. So it would have procedurally had to have happened is first Lambert should have been granted his hearing on the 5-day suspension. And that's under MGLC 31, section 40.
That's the May 13th hearing.
Yes, Your Honor.
And then what should have happened?
Well, during that hearing, Your Honor, Lambert may have been completely exonerated, and it could have been.
Okay, but let's say he wasn't. Let's say good cause had been found. How does the 55 days ever show up? When and how?
So if the city wanted to prosecute that 55-day recommendation, they could have, but they didn't. What would have happened is there would have been an additional hearing at that point.
There has to be a second hearing after the good cause hearing about whether that recommendation should be carried forward.
Yes.
Now, at the May 13th hearing, it's a hearing examiner or something designated by the appointing authority. Is that person also asked to pass on whether they agree with or disagree with the recommendation of the 55 days, or it's a wholly separate proceeding?
It would be the former, Your Honor, because again, during that hearing, it would have been decided in the first hearing on the 5 days whether there was just cause for that at all. And of course,
if there was, that same hearing examiner would say, and by the way, appointing authority, I think 55 is good, or I think 55 is too much.
And then at that point, the appointing authority in his discretion would then call a hearing.
So that hearing was in fact about the 55 days as well as good cause.
There would be a separate hearing on the 55.
I'm sorry, a minute ago you said that there'd be a recommendation made at that hearing by the hearing examiner.
There could be, Your Honor.
Okay, so that could have been the 55 day hearing, and it was never held.
The primary purpose for that 5-day hearing.
I'm not interested in primary or secondary. I'm trying to figure out, you've said they failed to prosecute.
Yes, Your Honor.
But if that hearing was the next step in prosecuting, then it was scheduled. We don't know why it didn't take place, but it wasn't like they just let it drop or never mentioned it again. It would have come up at that hearing.
Is there anything in the record once the appointing authority received the recommendation of the chief, because he could not exceed the 5-day suspension, did in fact the appointing authority issue a notice of intent to implement the 55-day suspension?
No, Your Honor, there were no steps that were taken to move forward with the 55-day recommendation.
And under our civil service law, what was the time frame under which the appointing authority was required to issue a notice of intent to proceed with the additional discipline?
My understanding is that it's within 5 days of the request of the first hearing, Your Honor.
So is it really that your argument as to the 55 days is that the city waived it by failing to issue a notice of intent to suspend?
Essentially, yes, Your Honor. It's unreasonable for the chief to hold the threat of that further punishment over a civil servant's head for years on end. It was 1,865 days actually that elapsed from the time that Lambert had requested
Does
the
the
hearing.
chief, though, need to wait until the 5-day suspension is adjudicated before proceeding with the 55 days?
Yes, because within the 5-day hearing, it could have been determined that Lambert's
Right.
5-day suspension.
Thank you.
Thank you, Your Honor. I see that my time has elapsed, but are there any additional questions that I might be able to answer for you?
Your time has elapsed. I see no further questions. Thank you very much. Excellent argument. Very helpful to us. We will hear now from you, Attorney Austin.
Good morning, Your Honors. May it please the court. My name is Attorney Janelle Austin. I represent the chief and mayor in this matter. As Your Honors are certainly aware, the LEOSA standard.
I'm sorry to jump in so early, but could we start where we just left off, which is, did your client sit on the 55 days? Shouldn't they have issued at least an intention to suspend? Because all we have in the record is the recommendation. We don't have anything that says that the appointing authority, in fact, was going to suspend him for 55 days.
Your Honor, thank you for the question. The record does have notification. I believe it's on in the letter dated August 22nd, 2012, which clearly indicates that it is
So
the
that's
chief's.
that record, what, 3738?
Yes, Your Honor.
And this is from the chief, but what do we have?
From the chief with, as Your Honor is aware, the chief is not the appointing authority. And so
Right.
pursuant to state law, the chief was only allowed to make a 5-day recommendation or a 5-day suspension, which Your Honors correctly point out was never served by Mr. Lambert. In addition, with a recommendation for the additional 55-day suspension, it's
Right.
the chief's contention or the appellee's contention that that hearing that was scheduled for May 2013 never took place, and that the additional 55-day suspension hearing, there was a hearing officer, we know that's in the record. The
But
city
doesn't the mayor have to act on the recommendation? In other words, the mayor could have received the chief's letter and said, you know what, I'm not going to move forward with any additional suspension, or I don't think it should be 55 additional days. I think it should be 3 additional days. We have nothing from the mayor with respect to the recommendation. We don't know that the mayor was going to proceed with this recommendation.
Your Honor, respectfully, I would assert that the letter dated May 2nd, 2013 clearly indicates that the mayor, signed by the mayor himself, clearly indicates that there was no waiver of that discipline.
Well, it just says that he designates a hearing officer regarding the police disciplinary hearing of Craig Lambert. We don't know if that's for the 5-day, the 55-day, or both.
Your
How do
Honor,
you know that?
I would submit that it was copied to Mr. Lambert's attorney. It's clear
Yes.
that it was related to it says disciplinary hearing related to the pending matter. We know that there was no intent by the city to otherwise resolve, or no intent by the city to otherwise not pursue the discipline.
Can you clarify something for me? Because
Yes.
I don't understand this. Okay, there's this recommendation. I have done, the chief says, all I can do. I've imposed a 5-day thing, but I recommend more. Your sister has used the word prosecute that 55-day recommendation. What is, let's say the mayor wants to figure out whether to do the 55 days or wants to do the 55 days, what is the next step?
Your Honor, the next step would be a hearing on that, a hearing
On what?
on the proposed additional recommendation by the
And,
chief.
and
of the
could,
55
and
days.
that would be before a hearing officer, hearing examiner, something like that.
That is correct, Your Honor, and that's exactly what took place in this case. As Your
And so
Honor,
you're saying that this hearing was about both, is there just cause and should there be more punishment?
correct, or less,
Now,
certainly.
there is a phrase that I'm not familiar with that Justice Blake has used, notice of intent to suspend. What's that?
With respect to the letter from the chief, Your Honor?
No, I'm asking about, is there such a document
Mhm.
that sometimes issues? And is it supposed to issue within 5 days? And what the heck is it?
Your Honor, I would assert that under the civil service law, there is a provision that the chief sent the notice on August 2nd, 2012, indicating the proposed discipline, the 5 days.
That's that long letter that includes the
Yes.
suggestion of 55. That,
Correct.
in your view, qualifies as this notice of intent to suspend, even though it doesn't say I intend to suspend you, it just says I intend to recommend to the appointing authority this lengthy or suspension.
It indicates the chief's intent to suspend, as the chief is allowed to do under Chapter 31, Section 41, Your Honors.
And
And
and if the mayor wants to accept the recommendation, he or she need not within 5 days do anything further.
That
Is
is
that right?
correct.
Okay.
That is my understanding, Your Honor, is that there was notification of Mr. Lambert's rights under Chapter 31. That was provided to the chief. We know that the record has a letter from counsel for the union, Attorney Lewison, that clearly indicates that there was a hearing rescheduled at Mr. Lambert's attorney's request. We know that Mr. Lambert was out on 111F status. We know from the record, Your Honor, that there was a further hearing scheduled by the city. There were affirmative actions conducted by the city to indicate no intention whatsoever to drop or otherwise dismiss the pending discipline with respect to Mr. Lambert. We do know, however, that Mr. Lambert retired in 2014.
I'm sorry, I meant this because I'm looking at the documents. Do we know why this hearing was not held?
No, Your Honor. The record is silent as to why that May 2013 hearing never took place. We know that it was scheduled. We know that there were actions taken. We know that there was a hearing officer appointed. However, Your Honor is correct that the record is silent as to what transpired up until from that date up until the date that Mr. Lambert retired in 2014. What we do know, and it's undisputed in the record, is, as Your Honors correctly point out, the 5-day suspension was never served. That's clear. We also know, Your Honor, that the issue as to the 55 days, the quote unquote additional suspension had not been addressed. There was no resolution.
No, but your sister suggests that that's waived.
Right.
That you sat on your rights or failed to prosecute, however you want to put it. And I'm just trying to figure out what the basis is for that. All we have is this letter that says this matter, and it doesn't specify what the hearing is exactly. And if some further documentary or other kind of notification were required to go forward, then we might be in a position where we had to say, well, but they didn't go forward.
Your Honor, I would certainly submit under Frawley that we know that there was no settlement agreement, there was no resolution of the discipline, either the 5 days or the 55 days. We know that the chief has broad discretion to determine whether or not at the time of separation, in this case, retirement from the Haverhill Police Department, whether or not someone has retired in quote unquote good standing. I would submit, Your Honor, that the record is clear that it is, not in dispute that Mr. Lambert did not, that the disciplinary was not resolved.
As to the 55 days, I'm still a little bit hung up on the notice provision, but let's assume that an additional notice of intention to adopt the recommendation is required. Does the 111F status essentially toll that civil service timeline?
Your Honor, I think that, yes, I think that we would submit. It was very clear based on the time frame, that Mr. Lambert went on leave essentially at the same time that this discipline was coming to fruition, so to speak, or the discipline and then the disciplinary recommendation.
But
we would submit, Your Honor,
still required him, I think, to go to IMEs or hearings relating to his medical status. So he's required to do one, but not required to deal with the suspension?
we would, as submitted in our brief, Your Honor, Mr. Lambert never chose to take any action to resolve the pending discipline. Separate and apart from the IME.
Why is it his burden? Why isn't it the city's burden?
Well, we know that the city had scheduled a hearing for May 2013. We know that the city had scheduled had done had imposed the 5-day suspension. We know from the record.
Well, if the city sua sponte scheduled the hearing, canceled the hearing, you would lose, but if it was canceled at the request of Officer Lambert, you would win?
And no, Your Honor, I think for purposes of evaluating whether or not the LEOSA card was properly denied in this instance, we would submit that you have to look at the date and the time of retirement. And in this case, we know based on the contents of Mr. Lambert's personnel file, which are in the record, that he was facing disciplinary issue. We know that he never left 111F status up until the very date that he retired.
But with respect to the 55 days, if you dropped that prior to his retirement by canceling the hearing, let's say that, two hypotheticals, somewhere not in the record, there's an email where the mayor writes to everybody and says, you know what, the heck with this, I'm done. Okay. Or there's an email from Mr. Lambert saying, I fear this hearing and please postpone it again. That doesn't make any difference here? Why the hearing was postponed?
I don't think so, Your Honor. And why I say that is because essentially, if we say someone never resolved, a police officer never resolved pending discipline that they were facing and chose to voluntarily retire, it would essentially render the good standing argument a nullity. We know that essentially what has to happen in order to receive, and let's be clear, we know that based on the briefing that this is a special privilege, so to speak, right? With respect to the LEOSA card, it entitles qualified law enforcement officers that retired in good standing to be able to carry with special privileges across state lines, and to then essentially allow an individual not to face or resolve either by agreement or otherwise, which is what Frawley says, pending discipline, whether it be a civil service appeal, whether it be, an action to proceed and say the city did waive its rights, which I don't concede, Your Honor, at all. But that would be the burden is on Mr. Lambert. What we do know is he never served the 5-day suspension. He received.
But what about the equities here, counsel, right? Because he gets the notice of suspension in 2012. He goes out sick or line of duty. He doesn't retire until 2014. So that's about a year and a half after the initial letter from the chief. And then he doesn't apply for this card for an additional 3 years. So are you saying that forever and ever and ever, he is precluded from getting this card? That there's no period of time that passes? I mean, he would have served the potential 60-day suspension umpteen times before he applied in July of 2017. And it's but for the happenstance of his injury corresponding with the suspension. Because if he hadn't gone out injured, even if he had served the 60 days, by the time he retires in 2014 and seeks the card in 2017, nothing's pending. So there's the equities trouble me here.
Well, I think I appreciate Your Honor's question. I think where we have to look is a snapshot in time. And so if we take it out of this case and say the analysis is whether at the time of retirement, regardless of whether the time in which someone applies, whether it had been later in 2014 or 3 years later, whether or not someone meets the legal requirements for which a LEOSA card should issue. This isn't a license to carry. We know this isn't a statutory disqualification or suitability issue with respect to the chief. But what we know, Your Honor, is that the chief is entitled to significant deference using his or her discretion to determine whether or not someone retired from the police department in good standing. And
So
what we
Lambert
know
will never be able to get this card, right? Because we
I would
always go
submit-
back to 2014 when he retired.
based on the policy and procedures of the Haverhill Police Department that were adopted, and those are part of the record, as well as the standards set forth in 18 USC 926C, as well as the CMRs, Your Honor, I would submit that under Frawley, the chief was entitled to deny the LEOSA card. And certainly, we've argued that in our brief as well. I see my time is wrapping up. I'd certainly be happy to answer any further questions that Your Honors may have.
Let's assume for the moment that the explanation given by the chief in denying the LEOSA card was inaccurate. That did not accurately portray the plaintiff's status on the date of separation. Okay, let's just assume that. How is it that we look beyond those inaccuracies to do what I hear you arguing, which is let's look through the record and see whether he was separated, whether he was in good standing at the time of separation? Do you have any law that tells us that we look beyond what was stated in the letter?
I think Your Honor can certainly look at the letter itself and the totality of the circumstances.
Again, my question my question was not clear, but it did say, do you have any law for that?
Thank you, Your Honor. I would submit that Frawley is instructive on this point, insofar as we know specifically that there was an open matter at the time, and that using the record of proceeding, which we know is the case for which these cases are reviewed under the certiorari statute, we know that what has been submitted in the record is that there was open discipline. So I would submit that the Frawley case, Your Honor, clearly supports the proposition that the court can look to the totality of the circumstances.
So in that case, was an inaccurate explanation given?
No, Your Honor, but I would submit, I would submit that it was not an inaccurate explanation.
I know that's a different question. I asked you to assume that the letter was inaccurate.
Yes, I would submit, Your Honor, that the court is entitled to look at the entire record of proceeding. And certainly we know that the discipline at issue here, or the discipline, the 5-day suspension, and the recommendation for the 55-day suspension stemmed from that internal affairs investigation. And I think that Your Honors are certainly entitled to review whether, in light of that totality of the circumstances, based on the record of proceeding present before the court, that you're entitled to submit. I submit, Your Honors, that the chief's decision was certainly not arbitrary, capricious, or an abuse of discretion. And the chief was certainly aware of the pending, the pending matter that stemmed from that internal affairs investigation. Thank you, Your Honors.
Thank you very much. Your time has expired.
We are live and on the record.
Good morning. Our session here at the Appeals Court continues. I am Justice Rubin. I'm joined today by Justices Wolahojian and Blake. Our next case is number 21-424, Palo Verde Capital LLC versus Board of Assessors of the Town of West Bridgewater. And we will hear first from Attorney Pellegrino.
Thank you, Your Honor. My name is Rayford Pellegrino, as you know, and I represent Palo Verde Capital, the appellant in this case. I won't go over the facts as they're very simple and straightforward unless there's questions. The confusion in this case comes from the fact that public property used for a public purpose has traditionally not been taxed, but are not statutorily exempt from taxation, and that's the key. The exemption from taxation for such property is not
They're not
founded upon.
statutorily in terms, I mean, here's where it gets tricky, right? They're not expressly exempt under the language of the statute, but they have been judicially exempted from the language of the statute.
That is correct, Your Honor.
Okay, and so then what I've been thinking about, and perhaps you can help me with this, is the line of cases that says that when we construe, we being the courts, construe the language of a statute in a certain way, and then the legislature either does nothing after that, or in the case of this statute, amends the statute, but doesn't disturb the judicial construction of it. We have then said it means that the legislature intends to incorporate our construction of the statute into its language. And that is, to me at least, the most difficult hurdle for your position. Because here, there's no doubt that there's no express statutory exemption for municipal property. But there's a longstanding judicial exemption. The statute has subsequently been amended without the legislature saying that judicial exemption is wrong. And then the appellate tax board here relied on that exemption in construing your tax appeal.
Perhaps I can approach it and answer this in two parts. The first part is initially the legislature intended solar developers, commercial solar developers, to have certain incentives to develop solar. The desire of the public was to have that happen. Uniformly, the ATB has granted exemptions for solar developers, except for this one limited nuance where they got caught up on the distinction of a public property used for a public purpose. If you look to the third prong of the ATB's test, I would suggest to you it's wrong, because it talks about property that's subject to a tax, not what the statute says that is expressly exempt from tax in this chapter, this statute 59. So what we have here is the public as a whole, including commercial solar developers, should be able to rely upon the plain words in a statute and the interpretation of them when they make business decisions to develop in the Commonwealth.
Right, but an interpretation of them is that the courts have said municipal property is exempt from taxation.
However, Your Honor, the statute which controls says that the property needs to be expressly, which is statutorily exempt from tax. We need, stare decisis says, we need not go beyond the plain meaning of reading of the statute. So the way I believe the court should look at it is, how do we determine which property is taxable under 59? We look at section 2. It says all real, personal, and personal real property within the Commonwealth, unless expressly exempt, is taxable. Then we go and we look at the section 5, which are the express exemptions. There's a laundry list of exemptions, but what's noticeable.
But I would have thought your answer to Justice Wolahojan's question would be the readoption of language that doesn't expressly exempt anything, doesn't expressly do anything. Maybe readoption in the face of something, but and particularly given that there's this other provision that says there's a difference between express exemptions and other exemptions, they can make it express anytime they want. I
agree with that. In my mistake, I assumed, and probably wrongfully so, that was embodied in what I'm saying. I guess the way, if I would try to respond to it, is the legislature had the chance to make it retroactive. They didn't do so. The limited, if this court were to decide in favor of the appellant, it has very limited impact. The floodgates aren't open for other parties.
This is a different point. There is this new, they have recently done something. I gather, I was going to ask you, because I looked very briefly at the statute, which presumably it's not retroactive, although I'll ask your brother about this. And so I didn't look with any great care since I thought it wasn't applicable. What is it they have done? They have now made this land expressly exempt?
Your Honor, they changed it to essentially take away the benefit of solar large-scale developments, so that there's 3 criteria. The first is you can only produce solar for 125% of the needs for your property and the contiguous properties that you own. Number 1. Number 2, 25 kilowatts, which is represented towards a small amount. And number 3, which is the key one, is if you have a large-scale development, you have to pay tax unless you do in lieu tax agreement. So the design is to take the benefit away and force parties.
So this whole thing, but it went away, but it didn't go away because of a difference between public property used for a public use and public property not used for public use. Or
I would suggest to the court, the critical thing they did is they took away that idea of what where the power is being provided to, what that property, how that was taxed, and they've eliminated that. And now they've said, okay, when you're producing, and these are.
And what tax year does that take effect?
I apologize, John, I didn't hear that.
What tax year is that statute take effect?
It was passed this past summer, and I believe it happened from the time. I think it's a certain number of days after it went into effect.
And what tax years are we talking about?
We're going back, it was 3 tax years. I believe it was 18, 19, 20. Okay. And I thought it might be 21 as well.
15, 16, 17.
Oh, yeah. I'm sorry, I forgot the COVID.
I know.
I apologize.
I want to go back to the topic we were discussing earlier. Mm-hmm. I understand your point about the plain language of Section 2, that it says all property is taxable unless expressly exempt, shall be subject to taxation. Mm-hmm. However, we have cases that say that language, that municipal property is exempt from that. You acknowledge that, right?
Your Honor, I acknowledge that that's a judicial
yes.
If I could just finish this
right.
one point.
It's a judicial exemption. It's a judicial exemption, yeah. Right? And so that language has been construed to not be as absolute as you're arguing here. Mm-hmm. It has already been construed to be limited. Mm-hmm. So how is it that we can now construe it in the way that you are arguing?
Because I think
we're bound by the decisions of the SJC.
Agreed. But the SJC has not opined on the specific issue. If this court were to grant the appellee's argument, you would create precedents that a judicial exemption is equivalent to an express statutory exemption. And I would suggest that's not
well, I don't know, because you're going to have to explain that to me, because okay. We know that the SJC has held that municipal property used for municipal purposes is not subject to taxation under Section 2. The SJC has held that. Mm-hmm. So if we accept that, because we must, mm-hmm. What happens to your argument?
That does not erode the distinction between and I've cited an argument that the cases in our appellant's brief, Section 1 under our argument, the distinction between a public express exemption and it can't go beyond this, because the SJC has not said that a judicially recognized exemption is equivalent to an express exemption, and that's the distinction. I would suggest if we look closely at the SJC's decisions, they don't opine on that. and it's not controlling. So the statute still is.
But what they have said is municipal property used for municipal purposes is not subject to taxation under section 2.
As as a judicially recognized exception, but again,
Okay,
go back.
but that's what they've said.
Well, don't you think that individuals and companies, when they're looking at a statute that has not been overturned or interpreted differently, and I would suggest they haven't said it's an express exemption. And I acknowledge it's a
How
very.
can it be an express exemption? The word expressly is in the statute. It's fine for the court to, I mean, I'll ask your brother this. I shouldn't be asking you this. I just, it seems like there's a word expressly in there. Yeah, it's exempt, but not expressly in the statute. It's exempt by judicial implication. But I don't know.
Again, and the court if you look at all of the cases from the court, there's a distinction between a judicial exemption and an express statutory exemption.
Okay, so now let's look at section 5, paragraph, I think it's 45, right?
Yep.
There we don't have the word expressly exempt,
Correct.
right? These, in your view, section 5 are the statutory express exemptions,
Yes.
right?
Yes.
Okay, so in paragraph 45, though, it just says, which is being utilized for things that are supplying the needs of property taxable under this chapter.
That's the key language.
Taxable under this chapter. Now, we would agree, I mean, I think we have to, that the SJC has said that municipal property used for municipal purposes is not taxable under this chapter.
I believe, and I don't want to represent this, but I don't believe it said under this chapter. I said I believe the case read is not taxable. Under this chapter, as it expressed, they didn't modify the statutory language, and I would suggest
it is taxable under the express language of the chapter.
It is taxable. I agree. No,
Under the under the express language.
No, it's not under the express language of the statute. It's not taxable. The statute is clear that that unless it's expressly exempt, which you go to chapter 5, and it's not listed as an exemption in chapter 5. So you start with 2. We know all property is taxable, personal and real, in the Commonwealth. And then we go for what are the specifically delineated exceptions in chapter 5, and it's not contained in chapter 5. This law has been around since the early 1900s. The law we set forth kind of legislative change in the 50s, and then the solar implications in the 70s. But all along, the legislature had the opportunity to change it. Even most recently. It's just till most recently when they changed it and they went back and dealt with this issue of how solar impacts it. Now, I would concede that probably the solar industry outpaced perhaps the legislative changes. But at the end of the day, we start with the statute, and the SJC does not override the statute because they didn't interpret it separately to say that it's that they've somehow construed it as an express statutory exemption under the statute. I don't know if you have another question there, but I was just going to make one other point whenever it's appropriate.
Was most of the tax here on personal property?
Yes.
Do you want to address the defendant's section 2B argument?
Yes, Your Honor. 2B is a red herring in this case. It's simply a shifting of the burden of taxation. So that if a private party essentially takes a public property, has control of it under a lease, it shifts the burden so that they can be taxed. It doesn't reach the end result that the appellee is suggesting, because again, it's a fee shifting statute. I'm sorry, tax shifting statute, where a private entity now can be taxed for public land they control. That makes sense because I'm leasing a public property. I now own it, and we're saying you shouldn't, as a private person, shouldn't have the same benefits that the state or the Commonwealth, may have. So that's all it is. It really is inapplicable, in my opinion, to the facts of this case, and irrelevant because it's a fee shifting. It doesn't usurp or somehow limit what's contained in clause chapter 5 of the statute on the limit on the types of uses which should be exempted.
Okay, I think we understand your argument. Your time has expired. Unless there are further questions, I don't want to truncate anything. Thank you very much. We will hear now from Attorney Gay. No, you're muted, Attorney Gay. You might want to, there we go.
Good afternoon, Your Honors. Attorney Tom Gay for the town of West Bridgewater. Our argument is fairly simple. The Appellate Tax Board has adopted a three-part test, which they, in our opinion, applied in their decision.
But the third part reads the word expressly out of the statute. I'm not interested in their test. I'm interested in the statute. The statute says expressly exempted, otherwise it's taxable. So I don't get it. State government-owned property committed to a public purpose is taxable. It's not expressly exempt, but there's an implied judicial exemption. What do you do with the word expressly?
Your Honor, I would say from an historic perspective, with the court's continued ruling that municipal property is exempt from taxation, and as one of your honors stated previously, that interpretation has been in existence for a significant period of time.
Yes, it's an implied exemption from 1940. It's from 1940. It's 80 years old. There's been an implied exemption. But this says all property, real and personal, situated within the Commonwealth, unless expressly exempt, shall be subject to taxation. And property subject to taxation is what we're concerned about here. So I don't understand what the age of the implied exemption has to do with it.
I just would submit that it's an historical exemption. It may not have been.
Is it express?
Codified.
Is it express?
I would say it's expressed in the case law in judicial.
I see. So your view is that expressly just means articulated, could be articulated by court or by the legislature.
In this situation, I would, Your Honor. It's something that has been customary in practice of the courts. It's customary in the appellate tax.
So when I look at Assessors of Quincy versus Cunningham at 305 Mass 418, and I read the following sentence, the exemption which the taxpayer seeks is not an implied exemption, as in the case of real estate held by a municipality or by a public service corporation for public purposes, but is an exemption expressly granted by statute, which suggests that there's something called an expressly granted by statute exemption and an implied exemption. You're now arguing that this reference to expressly exempt in section 59(2) includes the implied ones. You see my problem with that?
I do. Trying to think of a.
I mean, you're not the ATB. They don't come before us. They just routinely uphold people taxing other people, and then they send those people to us to sort it out. But I don't understand. Their three-part test doesn't seem to have expressed.
I actually let me try this a different way. Would you agree that the exemptions in Section 5 are express exemptions?
Yes, Your Honor. I would say that they are.
All right. I think so too. So one of the express exemptions, and this is the one that the taxpayer here is relying on, is paragraph 45. Paragraph 45 does not use the word expressly exempt. Instead, it uses a different phrase called taxable under this chapter. That's the language of I take it that's probably why I don't know, but that is the language in the third part of the test used by the ATB. I take it your position is taxable under this chapter incorporates the judicial exemption for municipal property.
Yes, Your Honor. I think that's a long-standing practice of the courts, the appellate tax board, and I think that is something that would be a logical conclusion of reading that section.
Okay, so your position is that because of judicial exceptions, because of those judicial decisions, municipal property for municipal use for municipal purposes is not taxable under chapter 59.
Yes, Your Honor. I think there's other reasons that it's practical to interpret that way. It prohibits, a rogue assessors board from going in and taxing properties within a town or a city. It's something that has always been judicially recognized, and I do not believe has ever been.
I'm sorry, I have your brief in front of me, and I thought your argument was there's an express exemption because of expressio unius des exclusio alterius of section 2B. I did not read you to say that section 45 treats an implied exemption as making something not taxable under the chapter.
I do believe that section 2B and how it states that if public property is used for a private purpose, you could infer from that if it's a public property used for a public purpose, that it's not taxable. So I think there are two arguments to be made with why the appellate tax board's decision should be upheld.
What's the other one?
The other one would just be the precedent, and that the section 45 doesn't say expressly.
Let me ask you this. The policy implications of the appellate tax board's decision seem to me completely cuckoo. That's a legal term. It increases the cost of providing solar energy to municipalities, because if the municipality is then going to go and impose if a solar energy supplier can provide solar energy to private entities under, paragraph 45 of section 5, and be exempt from property and real estate and property taxes, then they're always going to do that rather than supplying it to municipalities. And that seems nuts. It also, because unless at the time of negotiation, I guess the alternative is the company charges the municipality more for solar energy than it would charge to a non-municipal entity. And that also seems to me contrary to public policy. It's certainly contrary to the public fisc. So can you please address those points, because they bother me?
Yes, Your Honor. So from I kind of refer to it in some ways like pretzel logic, but however, if you have a solar farm that is selling its credits or using its credits for a private entity, the private entity is going to be paying real property tax. There's going to be some tax revenue derived from that arrangement for the municipality. In a circumstance where you have
but it would get that regardless, it would get that property tax regardless of where the business was getting its energy. If the property tax would be the same on that business, even if it was buying coal burning energy, right?
Correct, but it's getting the personal property exemption on the solar array equipment, where in the circumstance that the present case, if Palo Verde Capital, which does not, to my knowledge, own the real estate, received a complete personal property exemption and sold it to the town, there would be, the town is not paying property taxes. Palo Verde is not paying personal property taxes. And it sets up a situation where there would be a significant gain to Palo Verde and a loss of tax revenue to the town.
Well, I don't understand the loss of tax revenue, because if Palo Verde were selling it to a profit-making enterprise, private profit-making enterprise, the town's municipal property would still not be subject to taxation.
Mhm.
The private enterprise buying the solar energy would be subject to taxation as it was before and to the same degree. And Palo Verde would not be taxed.
Mhm. No, I do
So
understand.
it's sort of, I mean,
your
it
concern.
sounds to me like a penalty on the solar, and I realize, penalty is a freighted word in tax context, so I'm just using it colloquially, a penalty on the solar provider for selling to a municipality.
Correct. And that is how the appellate tax board has interpreted it and how we would interpret the statute. The legislator, when they created this, they may have had an intent or a reason. There could have been a negotiation for that. I do agree that the logic, when you actually play it out, does seem, kind of pretzel in nature, to use a different term. But that is the precedent that we have with the appellate tax board. And when you interpret and imply the statute as drafted, that's the outcome that we do have.
Would you agree would you agree that paragraph 45 reflects the legislative intent to encourage people to encourage solar developers by exempting them from property tax?
Yeah, I believe that the tax scheme for solar, wind, renewables is to encourage growth of that industry.
So
However,
how is it that this interpretation of section of paragraph 45 furthers that legislative intent?
From implying it probably would deviate from it if you look at how it actually plays out once applied.
Right. So we have like thousands of cases that say the purpose of statutory interpretation is to further the legislature's intent. So that troubles me, to be frank.
No, and I understand your concern in reviewing the appellate tax board's decision. In this case, in the town's position, we believe we've followed the precedent that we have to follow. And that's what I can submit to you today.
So I had another question about section 2B.
Mm-hmm.
So I understand your 2B argument to be essentially a sort of one by analogy, that because something's not included here, it must have been included, But section 2B refers to real estate, tax on real estate. And so I was a little confused because I take it that the taxpayer, which you've clarified for me, that the taxpayer faced was tax on personal property, not real estate tax.
With respect to Palo Verde, yes, I believe the town was taxing their solar array equipment.
Okay, thanks.
You don't have anything to say about this recent change? You don't think it's retroactive or?
I don't think it would apply to 15, 16, 17. It doesn't state that expressly.
And it doesn't shed any light about what the legislature is currently thinking about this particular problem. It just gets rid of the issue in some weird different way.
It does. It talks about the size of the systems and the kilowatts and capacity.
But it doesn't distinguish public property used for a public purpose from anything else.
No, Your Honor.
Under the new statute, would the result be different? For these
I haven't
years?
really applied it to this specific fact case, so I don't think I'd be able to provide you an answer on that question.
That's fair.
All right, I think we have your, unless you have more, because it's your time.
No, Your Honor, I think that the precedent is what we followed. We followed the Appellate Tax Board's proceeding, and we'd hope that you affirm their decision.
I have another question. I'm sorry. I know this is outside the record, but what's going on with the subsequent tax years? Can you tell us, are those also in a similar posture, but have not yet been decided? They've been challenged? Is the taxpayer appealed them? Town taken the same position? Do you know?
I don't know what is going on with 18, 19, and 21. My brother would likely know. A lot of times I don't receive the file until it's pending with the Appellate Tax Board.
Sure.
I see. Thank
All
you.
right, your time has expired. I think it's a really interesting case. I don't know what my colleagues think, but I do. So thank you both very much. Excellent argument.